Welcome to This Week in Family Law, the go-to podcast for busy Australian family lawyers who want to stay updated without the overwhelm. I'm Brendan Chu, and with me today is our newest member of the team, Nicole Smith. Nicole, your first full podcast episode. How are you feeling?
I'm excited, Brendan. Thanks for having me here, and I'm a bit nervous, but we're ready to get into it.
Fantastic. All right, let's get into this week's updates. Nicole, what's up?
Okay, so first up, we've got the national and state statistics on marriages and divorce. So the Australian Bureau of Statistics released these based on 2025. In 2025, there were 118,804 marriages registered, which is actually 1.7% fewer than in 2024. And the actual crude marriage rate fell slightly to 5.3% per 1,000 people. The median age at marriage was 32.7 years for males and 31.2 years for females. And of those, so there was 4,636 marriages registered for couples of the same or non-binary gender, which was down 2.3% from 2024, but represents around 3.9% of all marriages and has been consistent over the last 3 years. In relation to divorces, this has actually increased by 4.1%. So there was 49,158 divorces granted in Australia in 2025. The crude divorce rate was 2.2 divorces per 1,000 couples. And the long-term trend remains down. So the rate was 3.3 in 2005. The median duration from marriage to separation actually increased to 9.5. Sorry, let me say that again. The median duration from marriage to separation increased to 9.4 years, while the median duration from marriage to divorce was 13.4 years, which was a difference of about 4 years. So taking into account the mandatory 12-month separation period required before the divorce application can be filed, it looked like it was then taking another 3 years for people to actually apply for a divorce. So whether that's because of parenting and property proceedings or if they're just taking that time.
Yeah, it might just be that they have in fact resolved their parenting and or property matters, but they just haven't actually done that process at the very end of the journey, which is just to get the paperwork done for the actual divorce application itself.
Yeah, absolutely, and paying that extra filing fee.
That's right, yes.
The median age for divorce actually increased. So for males, it was 47.3 years and 44.4 years for females. And from an age-specific divorce rate, so it increased for all male groups from 40 to 44 years, and for females, 35 to 39 years. But divorce rates fell slightly for both sexes in the 25 to 29 year age group and the 30 to 34 year age group.
Looking at the stats for the median age at marriage, that sounds like to me that people are just waiting till they're in their 30s to get married. That's perhaps why the age range from 25 to 29 has in fact dropped for the divorce rates there.
That's what I thought too. And I thought it was interesting that the length of time that people were together went to 9.4 because there was always that saying about 7 years, that if people got past 7 years, they'd be okay.
Well, clearly that's not the case. I think if they get to 7, they're still at risk of the 9-year war.
That's right, yeah.
Actually, now speaking of divorces, some news for practitioners who work in the area where they're making divorce applications. So from 31st of August this year, all divorce hearings requiring an attendance before a deputy registrar will be conducted via Webex, so video. This will replace the long-standing tradition of appearances via telephone, which many of us, I'm sure, we're used to now. So this comes off the back of a very successful pilot in Parramatta, Townsville and Rockhampton. So in terms of how this will work, some of the practical applications of this. So a single static Webex link for each divorce list will now appear on the ComCourts portal, and the daily court list from 4 p.m. Australian Eastern Standard Time the day before. So there'll be no need to hunt through inboxes, which I'm sure are very full, for a unique link to join. And parties can join by computer, smartphone, or any other device that supports video conferencing. Of course, the Deputy Registrar themselves will appear by video, and parties and practitioners are expected, of course, to do the same. So what this means for practitioners and their clients means that being dressed appropriately is important. I'm sure there was a lot of conversation about that during the COVID era as well. And of course, that's now carried through to today as well. So the usual court etiquette applies. No more dialing and via phone in your pajamas, which is probably a bit unfortunate for those who are used to that.
Yes, please wear a jacket.
That's right. And dress appropriately and do not smoke on the video call.
And don't be in bed or in a car.
That's right. Just sit at a desk. And technically, whilst a party can appear by telephone or without video, the registrar retains the discretion to allow or deny that where there are safety concerns or technological limitations. For us practitioners, of course, this change brings divorce proceedings in line with the things that we're used to doing for other court events. So again, appearing via electronic means. So again, dressing appropriately, observing the usual court etiquette, which I'm sure we're all used to at this point.
Yeah, and I think it'll make it much easier than the phone calls and being on hold and not quite knowing
whether you've dialed the right number and also entered the correct PIN code as well. So I remember those.
How to come off mute as well was
Yes.
often an issue.
Yes, that's right. I'm sure now it's much easier just to click the mute and unmute button and turn your camera on. You can see yourself as well. So hopefully that'll clarify things for practitioners.
All right. We have one in relation to defamation, which is not technically family law, but I was excited to see that Rebel Wilson won her defamation battle. So the federal court dismissed a defamation claim against her by the Deb co-star, Charlotte MacInnes, over posts suggesting that MacInnes retracted a sexual harassment complaint to advance her career. Justice Raper found the one post carrying that imputation wasn't defamatory and wasn't satisfied that the reputation suffered serious harm. So the claim was dismissed with costs and an appeal is being considered. There have also been some changes to the Supreme Court's administrative arrangements. So for those family lawyers that also practice in the Supreme Court, from the 7th of September, the list arrangements have changed so that Justice Pike is now the class actions list judge for the whole court. Justice Williams takes real property. Justice Nixon takes corporation, and Justice Emmett takes admiralty. Chief Justice Bell thanked Justice Black, who ran the corporations list for over a decade.
Fantastic. Thank you, Nicole. And that's what's up for this week. For Law in Motion this week, we're going to be talking about the Hague Convention, the recent 60 Minutes episode titled The Point of No Return, and the court's public response to this. Over to you, Nicole.
Thanks, Brendan. So for those that haven't seen the episode, what I want you to picture is a scene of a young girl crying, carried away from her mother, put on a plane to Belgium, an allegedly violent father waiting at the other end, and an Australian court that sent her back anyway. So the episode was made to make you feel angry, upset, and to feel like the court did the wrong thing. But I want to talk about the cases that are underneath the episode. So we've got case one is DCJ in Bamfield. So it was a First Nations Australian mother. She brought her infant daughter back from Belgium to Australia for what the father understood was a 2-month holiday. Days before the return flight, she told him that they're not coming back. He triggered the convention. There was a 3-day contested hearing. Return was ordered and the appeal was dismissed. And she then applied for special leave, which was refused. When the mother wouldn't confirm whether she would travel with the child or not, the court placed the child in the father's care to effect the return. The second case was the secretary of the DFFH and Whiting, and it was a Dutch mother bringing her young daughter from Belgium to Australia without the father's knowledge. It actually happened the day after a Belgian court had continued a prohibition on taking the child overseas. It was the same pattern. Habitual residence was found to be in Belgium. Return was ordered, appeal dismissed, and the return was enforced. A later attempt to recover the child back to Australia was dismissed as frankly fanciful. So for anyone who hasn't seen the program, the central claim by both mothers was that they had evidence of domestic violence and abuse, and that they put this before the court, and the court would not accept it, would not consider it, and sent the children back anyway. The reporter said plainly on air that under the Hague Convention, there's a key defence a mother can argue, and that returning the child puts them at grave risk of harm. And he's right. Grave risk of physical or psychological harm or an otherwise intolerable situation. It's argued regularly, and it does succeed. There are published decisions where children have not been returned for exactly that reason. In Whiting, it was never actually raised. She contested habitual residence and nothing else. In Bamfield, it was raised but then abandoned before the final hearing, and her own counsel conceded that the physical harm limb could not be maintained. So in both cases, the fathers were ordered to fund the return. In Whiting, that included flights and accommodation, and in Bamfield, it was housing, a car, an allowance, health cover, and there was an order made that the child would live with the mother once in Belgium. But neither mother got back on the plane. 10 days after the broadcast was made by 60 Minutes, the Federal Circuit and Family Court of Australia did something it almost never does, and it answered back publicly, point by point. And what the viewers feel about that will be the interesting part as to why that happened. So I guess the question is, do people understand that the court, when they're looking at the convention, is not actually necessarily determining is the child safe? It's actually there to determine what jurisdiction should be determining is the child safe. And I think that's what wasn't made clear in these episodes, and why the court, in my opinion, felt the need to respond to
That's
this
right.
episode.
Yeah, I agree. And also at the same time, I do believe a lot of these programs do try to, I guess in some cases, push a certain narrative, and potentially the court felt it was necessary to push back against that. And also, these cases go to show that the court isn't able to consider things that aren't raised at the actual hearings themselves. And if counsel or if parties actually concede on certain issues, then the court simply cannot go and say, well, despite that, we're going to consider X, Y, and Z. So actually, it's often not known to the public until you read the judgment that certain issues were, in fact, either not raised, there was insufficient evidence, or in some cases, there were said to be evidence, but that was not put forward to the court as well.
Yeah, and I think the court made that point in their response, because they actually say in their response they provided the anonymised judgments to the program before it was aired, but it didn't appear that this evidence made it into the actual episode itself. And you do feel sorry for the mums. I can understand, and it's not to say that nothing actually happened.
Of course.
One of them, I think, stayed in a refuge from what I read, and certainly there were allegations. It's just that the threshold they have to meet is grave. It's quite a narrow,
That's
right.
right.
It's a difficult high threshold to meet.
That's right. The bar is certainly not low, and it's deliberately not low. But and of course, you can't imagine what these parents and the children have to go through to relocate. It's not an easy decision. No one wants to just simply pack up and move halfway across the planet. It's not a split-second decision that someone makes in the heat of the moment. It's something that they've had to seriously plan and think about. And really, it's a last resort. Parents don't just pack up because they don't want to see their exes anymore. It's because they think, there's nothing left for me in this country. The system's either failed me, or I cannot continue living here with my child. The only way is to go somewhere else, in this case, come to Australia.
Yeah, and I think it does say a lot about the trust that these mums obviously had in the Belgium system, that was lacking. But unfortunately, unless they can show that they're actually habitually resident in Australia, Australia is not the forum to determine the matter. So it has to be determined in the Belgium courts. And I guess one of the questions is, well, why didn't the mums go back to Belgium? There was safety measures put in place. So from the court's perspective with these Hague Convention matters, they say they will really only stop the children being returned to the place they're habitually resident if adequate safety measures can't be put in place. So from the Australian court's perspective, it looked like they were satisfied that the arrangements they had put in place would keep the mums safe. And so I think it is a question of the mums, why they didn't. But again, we don't know what lives they have lived.
That's right.
Even if the court felt they were safe, they might not have felt safe in that regard going back. But I think, it would be a difficult decision for someone to make, whether they felt their child would be safer without them being there, because we do know that a lot of the family violence that can be exhibited often escalates when there is conflict between the parents. So perhaps the mum choosing to stay in Australia, they felt that was safer for the child if the child was being made to go back to Belgium.
That's right. Yeah, we will never know exactly the motivations behind it. Only the parents themselves will know. Only the individual making that decision to move overseas will know. But it could be a factor. Like it could be a mix of different factors, including, like you said before, the loss of the trust in the system in their home country as well. So many things can be impacting that decision. But it's always a difficult case to deal with, and it's never a pleasant one, because in some way, shape, or form, there's heartbreak, and there's this massive uprooting of a child's life for them to be shipped around, essentially.
Yeah, and there certainly does need to be some reform looked at with the Hague Convention. I think we were looking at the timing, and in the episode itself, it said that it's a bit of a check-the-box system for the perpetrators, that there's no background check done on them. They check 3 boxes and the child back on the plane within 6 to 8 weeks.
Which is not true, not reality whatsoever.
No.
Because 6 to 8 weeks, that's a pipe dream, if anything.
Yeah.
And the reality is, if you look at the timing for a lot of cases, it can be 20 months, 24 months, even longer.
Yeah, exactly. So I think these are ones that, and I think it was made to look like this was a off-the-cuff decision that the court just set the child back, whereas these are actually cases that were looked at in detail. Like, it was a 3-day hearing. I think the judgment was 243 paragraphs eventually. So I think it's not something that's off the cuff. It's looked at over time. I think one of the trickiest things as a practitioner looking at it is that if this child has then been living in Australia for that 20 months or 25 months, whatever it is for that case, that child's then established in Australia.
That's right. Yeah.
So they were uprooted once when the mother did move, but then because of how long that court process does take.
Is it then appropriate to uproot them a second time and send them back because they're now established, they now have relationships with people in their new home country? Well, I'm not going to call it home country, but new country that they're living in. So, yeah, that's definitely going to make things, the waters muddier, that's for sure.
Yeah, and I think it was certainly... I think the ideal in the article, I think the convention article said the ideal was 6 weeks, but it's just not realistic for that to actually be done. That's a really tricky point, I find with it.
If we think even for like basic consent orders matters where parties are in agreement, that usually takes more than 6 to 8 weeks from time to time.
Exactly.
So I can't imagine in such a high conflict situation where one party's felt the need to uproot themselves and the child and move overseas. 6 to 8 weeks is simply not realistic, but it's an ideal we can always shoot for, but it's not reality. And I think one of the practical takeaways here really is that prevention is the best solution in many of these instances, especially if you're here in Australia, utilising things like the AFP watch list, putting a notification on passports, preventing the children from actually going overseas might be the best option for clients who do feel that their ex might take the child and suddenly decide to move overseas.
Yeah, I think if practitioners are alive to there being a risk of that happening, and I think you can't assume that it's not going to happen. I think you're better off assuming that it may happen and then putting those protective measures in place until you've got orders in place that can protect that.
That's right.
I think that's definitely
better to have
needed.
it and have those protections and not need them than to need them and not have them, of course, as we
Yeah.
can see in these cases and many, many others that are reported over the years.
Yeah, and it was an interesting point in the cases as well, because I think one of the practitioners in the episode said that there had never been any cases where the mother had alleged domestic violence and under the grave risk limb and the child had been kept in Australia to protect them. But we actually did some searching and we've put those cases in the case notes for people to look at if they want to. But there's certainly been cases where that's happened. There was one, I think that was actually in 2020, which was before these two cases. There was some legislative reform to the Hague Convention regulations in 2022. So there's been some that have happened after that. So there's a more concerted look at family violence since those amendments. But it has happened in cases that were able to meet that evidence threshold.
That's right.
And so I think it's about
out there for
Yeah.
those who are interested enough to read.
That's right. So make sure that if you do have that evidence, or you have that allegation, you've got to get the evidence to back it up. And I think it's making sure that clients actually understand that if there is a cross-international or cross-country risk in their case, it's about working out, well, which country is the country that's going to be running the matter or hearing the matter.
That's right.
And then preparing the evidence for that country. Because one of the cases had many judgments made in Belgium as well. And the mum was telling the Belgian court different things to what she was telling the Australian court as to whether she was going to live there or not. And I think you need to be consistent because the courts can talk to each other, but you need to understand the law in that country as well.
She's probably doing herself no favours telling two different courts inconsistent things in that situation there as well.
And I think it went to her credibility, unfortunately.
Unfortunately, it does, yeah. Thank you, Nicole. Lots of practical insights and takeaways for our listeners. In this week's Case Note Corner, we're going to be taking a look at Catlin and Catlin. And as always, the full case citation and a link to the case will be available in the show notes. Over to you, Nicole. Take us through the case.
Thanks, Brendan. Now, you will remember this one because for our LEAP Family Law Forum members, they have access to a video of you going over Catlin and Catlin number 3, where Justice Parker referred the husband's solicitor to the Legal Profession Conduct Commissioner over serious concerns about his role in a loan transaction that breached family law orders. But today I wanted to provide a quick update on what happened on the money side. So this case began back in 2016 with what should have been a clean break. There was consent orders requiring the husband to pay the wife 60% of the work in progress of his former financial services practice. Later in enforcement proceedings, this was declared to be $724,426.49, plus a super split with a base amount of just $130,623. So despite that consent order and the husband collecting over $1.6 million in work in progress, nearly a decade of enforcement litigation followed. So on the 13th of January 2026, the court made orders that required him to pay the wife $566,119.08 in interest for his failure to comply and $181,219.39 in enforcement costs. On the 10th of February, the husband filed a notice of appeal. This was amended on the 1st of April, and he was seeking to set aside those orders. However, about 16 hours before the security for costs hearing, he filed a notice of discontinuance, abandoning the appeal without any explanation. So the wife applied for her costs of the appeal, and the full court found the appeal unmeritorious and pursued for tactical rather than bona fide reasons, and ordered within 30 days the husband pay a further $23,418 on an indemnity basis. So on top of the principal he already owed, he now is up for more than $500,000 in interest, another $181,000 in enforcement costs, and over $23,000 for the appeal he walked away from. So recovery for this is to come from the sale of the former matrimonial home, and I just think it's a very costly case of non-compliance with court orders, and possibly for his solicitor, as the referral shows, the risk doesn't stop with the client for this one.
That's right, yeah.
And I thought what I would add on to this as well is some relevant rules that relate to this case. So we've got Rule 10.17, which is interest on unpaid money. And I just wanted to point out, because I don't think everyone knows, but that order actually runs automatically. So what the rule provides is that the rate of interest is for each half year period. So 1 January to 30 June and 1 July to 31 December. And it's 6% above the RBA cash rate. So interest accrues by default under Section 117B. You don't have to ask for it, and it isn't confined to enforcement proceedings. It applies to any order for payment of money, including a property settlement sum a party simply doesn't pay on time. The rate resets twice a year, and at the moment, the rate is 10.35%. So it's well above most commercial borrowing costs, which makes a real lever when a pay is slow to settle. And it's simple interest unless the order says otherwise.
Wonderful. And I think there are some practical takeaways here for some of our listeners. And the first is that I've noticed, at least certainly from my own experience, that a lot of practitioners tend to actually expressly draft an order saying that interest is payable upon non-compliance with a certain order that requires party A to pay party B, when, as you just mentioned, it actually applies by default. So practitioners don't actually have to go to the lengths of drafting that order into their minute of order, which should hopefully save on a bit of time and a few lines on the page. And the other is actually mostly going to actually advising clients that they should just comply with the orders to begin with. I mean, looking at this case that we just talked about, where the party themselves is actually up north of 700 grand owing to the other side because of non-compliance with orders made a decade ago. Had they just paid that amount, they wouldn't have to go through this entire process and still be out of pocket for over 700 grand. So I think making sure your client just complies with the orders that they agreed to is the easiest way to avoid a situation like this to begin with.
Yeah, absolutely. And he's going to have his legal costs as well.
That's right. And it looks like in this situation, the practitioner is also up for some potential issues, or sorry, not issues, but consequences as a result of their potential failure to advise a client and to make stuff just go in line with the orders in this case here.
Yeah, like they weren't strong enough to stand up to their own client is what it felt like.
That's right. We've loved being in your ears this week. Don't forget to like, subscribe, and share this episode. If you have any questions or feedback, you can reach us by email or on Instagram, TikTok, or YouTube. Stay tuned for next week's episode. New episodes drop every Monday.